Hi, Lorraine.
Hi, how are you?
Yeah, we didn't think we'd be back that soon.
Indeed.
After recording our Section 44 video last week, and now we've had Barnaby Joyce in the lower house, and therefore direct implications on the ability of government to govern the country. We've now had Fiona Nash and others. What's happening?
Well, it seems that a significant number of our parliamentarians may well be ineligible to be in Parliament, and more news keeps coming every day. I mean, this is a situation that was extraordinary when it started, to have one senator referred to Parliament, referred to the High Court, and now we have 6 who've already been referred and potentially more to come.
So is this an incident, if you will, an occurrence that shows us that people didn't care in the past and therefore didn't look very closely at this aspect of eligibility, and now it's coming out like an avalanche, or must be?
It certainly seems that some people haven't perhaps taken the section as seriously or been as diligent as perhaps they might have been. But when you look at some, for example, Senator Sam Dastyari has come out in the last few weeks and shown the quite extraordinary lengths he went to make sure that he wasn't a dual citizen and that he'd renounced his Iranian citizenship to the necessary extent. So some seem to have taken it very seriously, whereas others perhaps just haven't turned their mind to it. And in the case of people like Senator Fiona Nash and Barnaby Joyce, it looks as though they weren't even aware that it was a possibility they could be a dual citizen, because of course they're potentially dual citizens by descent.
And then of course Barnaby Joyce has already been dubbed in the Parliament by the Prime Minister as the quintessential Aussie. Which of course cannot be a legal test in the light of Section 44. How Aussie somebody comes across, nobody doubts his loyalty. I don't think that's the issue here.
But that does show in this case how the precise legal parameters of Section 44.1 might indeed end up being quite removed from the original purpose of the section, which was to ensure loyalty in Parliament. I don't think anybody suggested that the 6 members who've now been referred aren't loyal to the
Is that enough for the
Parliament.
High Court to get the Parliament out of this conundrum?
Well, that might not be enough for the High Court, and that's the really interesting thing about this. While there's confusion at the moment, the process that we have, and in some respects this shows the robustness of our constitutional processes, this will go to the High Court sitting as the Court of Disputed Returns. They presumably will provide clarity as to the outer limits of Section 44.1, and once we have that, the situation as to the current 6 who've been referred will hopefully be much clearer.
So would you agree with me that the High Court, if you will have to face a number of options? One option could be to try to be as close to Section 44 as possible in the light of his past jurisprudence on the issue, and perhaps only define a little bit more precisely the reasonableness criteria, and for example say you've got to check your parents, but for example you don't have to check all the way back, great parents, great grandparents, because all of this could of course have an impact on your citizenship, which depending on where you come from could be quite hard to actually find out.
Oh, absolutely.
Or would they go as far as you suggested, but as you indicated, one could also look at the whole thing and have which is very close to my legal background, a real object and purpose test, and therefore move much further away, if you will, from the language, from the wording of Section 44, and really look at the material content.
Well, it's a really interesting interpretation question, because if you read Section 44, subsection 1, literally, it is enormously broad. The High Court have already shown that they won't do that, and in Sykes and Cleary number 2, they read it in a more narrow way that accorded with the object and purpose and put that reasonableness criteria into it. But now that outer limit really does need to be clarified. So as you said, there are a variety of routes they could go down, but what is really significant is, I think, the way this situation has developed, and the fact that 6 people have now been referred. In addition to that, Senator Nick Xenophon came out today and said he's asking questions about his potential British citizenship. So there's a 7th person already on the record as saying they might have a problem with the section. And I think we are really at the point where this drip feeding of revelations day after day is creating a a sense of, I won't use the word crisis, but certainly it's creating a problem of confidence in the legitimacy of our Parliament. And I think we are at the point where we do need to draw a line in the sand and consider, for example, an audit, which is what both the Greens and Darren Hinch have been calling for, where we actually sit down and take stock of all of our current parliamentarians and work out who may have issues under Section 44 and have the High Court deal with all of those cases at the one time.
So that could be an option on the pre-procedural side before it goes up. The other options then would be for the High Court to take a strict view, if you will, and say, okay, show me the reasonable steps you've taken, if you if there was reasonable cause, and maybe say what reasonable cause is.
And of course, the interesting thing about that is it reverses the onus, because we're forcing somebody to prove their eligibility rather than the other way around.
Which is problematic in itself. So I think there will be hearings
next Thursday.
So my suggestion would be we'll wait for the hearings and we'll come back here and then have a bit of a discussion around what came out of the hearings, if anything that can be discussed.
Absolutely. And the one other thing we should mention about Section 44 before we go for today is, of course, there's one other potential controversy that may end up being referred through, and that's the case that's come out today of Senator Barry O'Sullivan from Senator for Queensland, who potentially has some issues under Section 44, subsection 5, and the question of an indirect pecuniary interest in contracts with the public service of the Commonwealth. So whether that ends up being referred through or not to the High Court, we'll have to wait and see. But it does just show that the dual citizenship requirement isn't the only one in Section 44
another
that's
audit.
causing problems.
Everybody gets audited on whether they have a pecuniary interest, a business interest that's somehow linked to the federal government. It is a bit over the top. We'll come back to it next week.
Absolutely.
Until then, have a great weekend.